بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد ختم الأنبياء وإمام الأصفياء وعلى آله وصحبه وسلم تسليما كثيرا. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Imam Ibrahim al-Halabi's Multaqa al-Abhur, we are continuing in the section on Qada. And Qada, as we saw last lesson as well, highlights many important principles for us as believers. And these principles also tell us about the importance of caution in the fulfillment of rights. Caution in the fulfillment of rights, in the securing of rights. And Qada also tells us that rights and responsibilities are fulfilled by having carefully established systems, so that trusts are rightfully discharged and protected. And the huquq of people are trusts. Right? So these are all go under general principles of the Shara as well. Inna Allah ya'murukum an tu'addu al-amanati ila ahliha. Truly Allah commands you that you discharge trusts to those they belong to. And in the case of Qada, what is the basis of Qada? Is that someone has a right that they are claiming. That claim may be right, so you're protecting their right, or the claim may not be correct, and the claim is being made against, their right is to be protected. So if we look at the principles of the protection of rights and ensuring that every step safeguards that rights are not a matter of mizaj, right? That of, well, the way I see it, yeah, it's fine, go ahead. No, we are an ummah of aql, right? Of deep thinking and exceeding caution, tamaman. So these things will be very clear in this lesson, right? So and we also see many issues here again on the method of the Hanafi school, particularly in fatwa. Why? Because a lot of the detailed rulings are not established simply on the basis of primary evidence. Right? The primary evidence gives us a series of absolute guidance. And even in the hadith, there's some guidance that is connected to urf, to the customs at the time of the Prophet ﷺ. And that's part of usul al-fiqh, to know what are the ahkam mustaqirra, which is the basis. Ma atakum rasul fakhudhuhu. What the messenger has come to you with, take it. But there's other things that does the majlis of the qadi have to look like the majlis in Medina? No, because that is circumstantial, right? That is based on the custom that was there. But there are principles that are understood from that. What's one of the principles that we took last time that is based on that we saw last lesson? Where should the qadi sit?
Ideally in the Jamia masjid.
Yeah, ideally in the masjid. It's best to be the masjid Jamia. If not, it should be in a makan zahir. Right? So they deduce that the specific place, all qada does not have to take place in the Masjid al-Nabawi. Right? So we see, and that's why, but there are details that are subject to change, as we see on many things, but it's not that they just change the rulings on a whim. Right? And alhamdulillah. So today we're going to look at the protocol for witness transfer and to gain clarity when a judge can judge based on his knowledge of the case. Right? And to understand the rulings about female and substitute judges and annulling a judgment, false testimony, and judging by another school or over an absent party. right? And issues of adjudication and its application. There's quite a few things. They're very detail oriented. So the first thing is the idea of witness transfer, transferring witness, or witness transfer, or the transfer of evidence, right? The transfer of evidence. And that may be that, okay, the claim is heard in one place, but the judgment, for various reasons, needs to be made in another jurisdiction. So how do you now hear the evidence here and then transfer it over? So there's a procedure in that based on the considerations of safeguarding the rights and not threatening them with tampering in the other. How does a qadi, or someone who has a position like that of the qadi, appoint a substitute? And because the qadi is appointed by the general authority, regional or absolute. Now, a person, so do they have independent authority in that sense? No. So there has to be a procedure for the appointment of the substitute. This is called istikhlaf. And again, it's not just on the basis of whoever the current guy likes, but rather it goes back to the same criteria, and there has to be an approval process, as we will talk about. Also, what happens if judgment was made on the basis of false testimony? And there's the issue of tahkim. So there's a whole number of things. نسأل الله سبحانه وتعالى اللطف والتيسير والتسديد في المسير. So transferring witness. في كتاب القاضي. And this is procedural. We don't have to dwell on all the details. The key thing is that if the evidence is gathered in one place, now the judgment is taking place in another. How do we take the witness from one one judge's jurisdiction to another judge's jurisdiction? It could be locally. It could be locally that the evidence was collected by one judge, but now for some reason, his son is marrying one of the witnesses' daughter. So, but before anything like that takes place, he hands over the case. واضح? But the other case could be that now the dispute took place in one land, they've all moved to another. So we have to transfer the case there so they can resolve the dispute over there. So he tells us, rahimahullah ta'ala, إذا شهدوا عند القاضي على خصم حاضر. إذا شهدوا, who are the shahidu? Sadati?
The two judges.
No. إذا شهدوا, إذا شهد الشهود. Right? If the witnesses bear witness, right? And it's in the plural because it could be two or more, right? So this is in the general sense of plural. It could be two, but it could be more than two, right? إذا شهدوا عند القاضي, right? So this is the first judge. على حكم حاضر. على خصم حاضر, right? And the person whom the case is against is present. What حكم بها? The judge would make a judgment on its basis, and that's the basis. Right? Zubair makes a case against Zubaydah. Witnesses come before the qadi, and the khasm, right, which is the mudda'a alayhi, the one the claim is being made against, is present. Is there anything now preventing the qadi to make a judgment there? No. And that's the default. So this is the default case that we've taken before. Inshallah يكون واضحا. وكتب بالحكم. And he records the judgment. He records the judgment. That this is the judgment that we are making. تماما. Now, so that's the default ruling. وَكَتَبَ بِالْحُكُمْ وَهُوَ السِّجِلُ. And writing this record is the register. Right? The sijil, which is the register of, in a register here of judgments. Right? And this term has come in the Quran as well, that in the records will be folded up. Right? And it's a sijil refers to, as Imam al-Haskafi says, is the name of the kitab, is لِكِتَابِ حُكْمِ الْقَاضِي. Right? This is the book in which the judgments of the Qadi are recorded. Okay. وَإِنْ شَهِدُوا عَلَى غَائِبٍ لَا يَحْكُمْ. But if إذا شهد الشهود, if the witnesses bear witness on someone absent, the Qadi will not judge. بل يكتب بها ليحكم المكتوب إليه. But rather, he records. يكتب بها بماذا؟ يكتب بماذا؟ يكتب بها أي بالشهادة. يكتب بها أي بالشهادة. Two witnesses bore witness. شهد الشهود. Right? It will be بالشهادة. Right? So the shahada is the meaning implicit in the ibara. لا يحكم القاضي. Why? Because can you make a judgment against someone if they're absent? No. They have a right to defend themselves. And they could have conflicting evidence. That would negate that witness. So rather, the Qadi would take the witness, right? So it becomes legally binding. This witness was delivered here, and all procedural elements were valid. لِيَحْكُمُ بِهَا الْمَكْتُوبُ إِلَيْهِ. For it to be, the subject of judgment from the al-maktub ilayhi, the one it was written to. وهو كتاب القاضي إلى القاضي. And this is called the transfer of evidence from one qadi to another. كتاب القاضي. This is the transfer of evidence from one qadi to another. وهو كتاب القاضي والكتاب الحكمي. And this is also the effective, or the recording of the evidence. Right? كتاب الحكمي. Right? Or this is the effective recording. It's effective because not, is this an actual ruling? Because what is the kitab al-haqiqi, what's in their register of rulings is actual rulings that took place. This is a recording of evidence that is being transferred to another judge to judge on the basis of. Right? This is why he says, وَهُوَ نَقْلُ الشَّهَادَةِ فِي الْحَقِيقَةِ. And it's a transferring of witness in reality. Right? Of naqlu shahada is the transfer of witness, or more broadly, the transfer of evidence. Right? It's a transfer of evidence. تماما. ويقبل في كل ما لا يسقط بالشبهة. And a transfer of evidence is accepted in everything that is not lifted by shubha. And what's the primary thing that is lifted by shubha?
Hudud.
The hudud. Right? The hudud. Right? The hudud and other criminal punishments. The hudud, the qawad, right? The punishments, right? Because they are deterrents, and the general principle has come that idra'ul hududa bishubuhat. Ward off the criminal punishments, the major criminal punishment, the hudud, and like them, the qawad, right? They're lifted by any reasonable doubt, even if it's in some cases far-fetched, as we see when we look at the punishments, right? Okay. So, and other than that, a witness can be transferred. So we can say evidence can be transferred by one judge to another. Primary case would be in the absence of the one the claim is being made against. So, what are things that are not lifted bishubha? Kaddain, like a debt. Wal-aqar, property disputes. Wal-nikah, wal-nasab, claims of lineage. Wal-ghasb, claims of misappropriation. Wal-amana, claims regarding a trust. Wal-mudaraba al-majhudatain, and an amana or a mudaraba that is being disputed. Why? Because if an amana is not being disputed, is there any reason to take it to court?
No, it's
It's an obvious thing, right? That I gave something in safekeeping to Sidi Abdul Latif, and he's not giving it back, but he's not disputing it. Can I take him to court? Abdul Latif, please give me my fancy turban back. It'd be ridiculous, right? It would be ridiculous. So that is the case of that's why this, but we've emphasized this, that issues like this, what should we do with them? We should just think of an example. That why would they say that it not be majhood? Simply by coming up with an example, and then we realize that it's very straightforward. We realize that it's very straightforward. Tamaman. So that's why this term majhood there, because if our item in safekeeping or a mudaraba, right, contract where the issue is not being disputed, like the mal al-mudaraba, for example, then it is given back and there's no need to take it to court. Rather, it would not be admitted to court because the court time is precious. وعن محمد قبوله في كل ما ينقل. And Imam Muhammad said, it is accepted in everything that is transferable. Right? So very وعليه المتأخرون. Right? Right? So in everything that is transferable, so that this makes it broader, right? Except, of course, so it only exclude had and qawad would be the exceptions. Tamaman. And then he says, rahimahullah ta'ala, so this is the fatwa position, عليه عمل الناس اليوم, right? Okay. وعليه المتأخرون وبه يفتى. This is what the later scholars are upon and what the fatwa is on, and this is istihsan. Istihsan. Why? Because it facilitates judgments. It facilitates judgments. Okay. And we can see what one covers and what the other covers if you look into the commentaries. It says, وَلَا بُدَّ أَنْ يَكُونَ إِلَى مَعْلُومٍ. A transfer of witness has to be to a specified judge, from one judge to a specified judge. بأن يقول من فلان إلى فلان ويذكر نسبهما, and to mention their lineage. And how much of the lineage one has to mention? One has to mention the name of the judge it's being sent to with that which specifies them sufficiently and clearly by custom. So if you're in a society where someone's lineage is not the default to be mentioned, that their name is mentioned with whatever is needed to identify them in a manner that distinguishes them from others. Is that, for example, someone, Sidi Abdul Latif, do you normally, is your passport name, do you refer to yourself as Abdul Latif ibn, your father's name?
No.
Do people know you like that in society?
No.
Right? I mean, if you went to a relative and said, I'm Abdul Latif ibn, whatever your father's name is, would people know who's being talked about? No. Many people wouldn't, right? It would be surprising. So يذكر نسبهما, the criteria is what we mentioned, that they be specified in a manner that excludes other people. So the recipient has to be clear. فإن شاء قال بعده وإلى كل من يصل إليه من قضاة المسلمين. Right? One can make it general. Right? So the case, there's ample evidence that Zubair has not paid his mahar. Okay. Now we can't find Zubair. So who is this judgment being sent to? Say, by default, we think he's in such and such place, goes to that qadi or to anyone else. So Zubaydah could take that, could request that this letter, this legal record of the evidence be now transferred to such and such qadi for them to make the judgment. And so the mahasin of this, the benefits of this, is safeguarding rights. And this, of course, can be done with cases of tahkim as well. Right? That if there is sufficient evidence against somebody, and we want as Muslims to resolve the issue outside of court, but the same principles, we look at tahkim, but the evidence, but the person left, they fled, and now they're in another country. What happens? Saying, okay, let's transfer this over to another muhakkim, and we take care of the judgment over there. Same rulings would apply, right? Because rights are to be, our rights are a serious thing. We can't just forgive it. No, that you can't demand virtue from people, and sometimes it's not virtue to allow rights to slip. Okay. ويقرأه على من يشهدهم عليه, and and the judge, يقرأه القاضي على من يشهدهم عليه. So the witness, the record of the witness is read to the people who witness this transfer. وَيُعْلِمُهُمْ بِمَا فِيهِ, and one informs the witnesses to this record. Right? So this record is witnessed. Right? So there's witnesses, but the judge wrote something down. Now, how do you know that the judge is not writing himself. The scribes wrote the right names down, etc. They're witnesses that this record corresponds to, is sound as the qadi said it, so that there isn't corruption on the behalf of the scribe or the translator or whoever. Right? وَيُعْلِمْهُمْ بِمَا فِيهِ. Right? And the judge makes them know, يُعْلِمْهُم, clearly regarding what is in it. وَيَكُونُ أَسْمَاؤُهُمْ دَاخِلَهُ, and تَكُونُ أَسْمَاؤُهُمْ دَاخِلَهُ, and the people bearing witness to this record, their names are in it as well. وَيَخْتِمُهُ بِحَضْرَتِهِمْ, and the judge seals this record in their presence. وَيَحْفَظُ مَا فِيهِ أَوْ يُسَلِّمُهُ إِلَيْهِمْ, and they either memorize what is within it, and that's superior, right? So that the people who are bearing witness to this record, right? These people will now be taking the record to the other court. It's best that it be done in two ways. They memorize the case, and this is what's in the record, right? That's the most complete. So the witnesses to this transfer of evidence know what the evidence is, like the two witnesses, what they said, the whole incident, they know it themselves, and the written record corresponds to it. Right? وَيَخْتِمُهُ بِحَضْرَتِهِمْ ويحفظ ما فيه أو يسلمه إليهم, or he just gives it to them to take to the other judge. Right? And their names are in it, that this is going. And of course, when it's sealed, such that this is it. A seal is not sought in itself. Do we have to use wax seals in our time? No, but we have to take all reasonable means that the evidence reach the other party untampered. Right? That evidence reach the other party untampered. That is the underlying criteria. And seals were very effective in that classically. وأبو يوسف لم يشترط شيئا من ذلك. Abu Yusuf said none of this is absolutely required. سوى إشهادهم أنه كتابه لما ابتلي بالقضاء. But Abu Yusuf said none of this is a requirement, right? That they witness the writing and they memorize it and etc. And this is what's in it. But rather, this is a record. It's being sealed in your presence, right? He just tells them this is from so and so that if, when it goes to the judge, they can bear witness. Yes, this is exactly what is the exact sealed document that the first judge had. Now, of course, the first is superior, but this is out of the practicality of there being an insufficient chain of preservation. Do we cause isqat of haqq as a result of that? No. واختار الإمام السرخسي قوله. And Imam al-Sarakhsi chose his position, the position of Abu Yusuf rahimahullah. And this is tasheelan. This is not out of strength of evidence, but out of facilitation. And unusually for a matn, they put a wisdom here, which is وَلَيْسَ الْخَبَرُ كَالْعَيَانِ. And, a report is not like seeing something. Because he had practical tajruba. But it remains in itself, the first is more rigorous. And having the rigor in place is superior. Right? Having the rigor in place is superior. But sometimes that will be facilitated where the authority of the government and its central institutions were strong, like the big cities, but also qada in rural areas, etc. And it's very hard to control a distributed system. تماما. وإذا وصل إلى المكتوب إليه نظر إلى ختمه. And if this record reaches the one it was addressed to, he looks at its seal, right, to make sure it is intact. And so it's untampered with. ولا يقبله إلا بحضرة الخصم. And he does not accept it, meaning he does not accept formally receiving it and opening it, except in the presence of the adversary, the one who the case is against. وبشهادة رجلين أو رجل وامرأتين. And he accepts it in the presence of two witnesses, two male witnesses, or one male and two females. So there's witness that this is the register come, it's untampered with. These people bear witness that it's come to us, and there's witnesses there that we are now opening it in the presence of the other part of the mudda'a alayhi, the khasm, the one the case is against. For example, أنه كتاب فلان القاضي قرأه علينا. That this is the record of so and so the qadi, يعني قرأه علينا وختمه وسلمه إلينا. So what do the witnesses say? They bear witness. This is the guys who bore witness the first time that this is the book of so and so the qadi who read it to us, and he sealed this in our presence, and he delivered it to us in the majlis in which this hukum was made. Okay, so the witnesses testify regarding the details. So, there wasn't an exchange of hands in the middle, etc., etc. This is the direct transfer. وعند أبي يوسف أنه كتاب فلان وخاتمه. Abu Yusuf said it's enough to say that this is the evidence, the record of evidence of so and so, the judge, and this is his seal. They don't necessarily need to know the details of any case, because there's also a practical thing that if there's like a witness, there's a legal record transfer service, you really expect that the witnesses would know the details of every case. They know. They've record, this is case number this, from this person to that person, etc. They have all this information. They're going to go deliver it to the other party. Right? So that is facilitative. But it needs to be done in a way that is secure. That is the underlying legal consideration. وعنه أن الختم ليس بشرط. And anhu, what does it indicate? وعنه, in a narrational. Anhu refers to, and in a narration from him. عنده, it's his opinion. Anhu, in one narration from Abu Yusuf, meaning that this is not necessarily the decisively, right? Decisively his narration, right? In a narration from him, which would be other than Zahir al-Riwaya, for example, that the seal is not a consideration. Why? Because what is the underlying consideration? That the Qadi has itmi'nan. The Qadi is reasonably sure, and a case could not be made regarding it being tampered. Of course, it being sealed is superior, but by not accepting this witness, right, this is a lesser harm than the harm of what? Than the harm of? No, the greater harm is that, okay, we have this evidence that has come from, this record of evidence from one Qadi to the other. The Qadi didn't stamp it, but there's witnesses are upright. They saw the Qadi write the ruling, etc. They heard the witnesses, etc., but it's not sealed. Is it ideal? No. But, so this is a harm that it's not sealed. But if we don't act upon it, what would happen?
Forego rights, possibly.
Yeah. We no longer have proof to establish a case, to secure someone's right and to ward off someone else's wrong. Right? And to ward off someone else's wrong. So that's why the this narration, now, would there be fatwa on this? This is a procedural matter, right? This is a procedural matter. Right? But this is why it could be a case that, in some land, they are lax about this. Do we negate the ruling? No. Especially because most cases are not these. We're not going to establish had punishments or life imprisonment or anything. A lot of cases are, the day-to-day cases of simple rights. Okay. That's why fiqh is not easy. Right? فَإِذَا شَهِدُوا فَتَحَهُ. If the witnesses bear witness, this is the majlis of the judge receiving this, he then opens it. وَقَرَأَهُ عَلَى الْخَصْمِ. And the second judge reads the evidence, the record of the witnessing, of the shahada of the shuhud. وَقَرَأَهُ عَلَى الْخَصْمِ, the adversary. وَأَلْزَمَهُ مَا فِيهِ. And now, because there's evidence, And evidence refers to this, the hujjah, right? Against. That's why one of the words for the kitab al-qadi is also what? Kitab al-hujjah, or the word for the register, the sijil, is also kitab al-hujjah. Why? These are the proofs against the one the proof was established against. Right? So قرأه على الخصم وألزمه ما فيه. Now we have proof against you. Someone made a claim. There's proof. So in the absence of anything to dispute that proof, it would be binding against the adversary. This is in the simple case that there's no counter proof. تماما. Then he tells us ويبطل الكتاب بموت الكاتب. This transfer of evidence is annulled if the one who wrote it dies, which is the first qadi, right? وعزله قبل وصول الكتاب. So this judge took the evidence, but they were removed. This evidence was taken, but the one in whose presence it was taken, the qadi, was removed. So now it's not, is the qadi, this is the record of evidence of someone whose judgment, who no longer has authority. So it's not binding anymore. So they have to take the witness again, just out of abundance of caution. We be mawtil maktubi ilayhi, and by the death of the one it was written to, unless illa an in kataba ba'da ismihi wa ila kulli man yasilu ilayhi min qudat al-muslimin, or a similar expression that generalizes the ruling to all those whom this reaches of the judges of the Muslims. تماما. And لا بموت الخصم, but this witness is not negated if the adversary dies. Why? Why would that not be an issue? Because if he dies, where could the right be taken from?
Inheritance.
From the inheritors, right? From his estate, if it's a material right, etc. So it would not negate every kind of right. So he tells us, rahimahullah ta'ala, بل ينفذ على وارثه, but rather the ruling would be binding on their inheritors, insofar it can be binding, right? So not everything is binding, like material rights, etc. are binding. Certain other things would not be, right? Like the punishments and so on. Because, if, as is obvious, right? Tamaman. So the material rights would be binding on the inheritor, not other kinds of rights. Tamaman. Then he tells us details related to judgeship. So he tells us, وَإِذَا عَلِمَ الْقَاضِي بِشَيْءٍ مِّنْ حُقُوقِ الْعِبَادِ في زمن ولايته ومحلها جاز له أن يقضي به. Right? If the qadi knows about something of the rights of rights of human beings during the time that he has jurisdiction, i.e. as a qadi, in his domain of jurisdiction, he can make a judgment on the basis of this. Knows, of course, decisively. So the qadi saw this misappropriation taking place, for example. So this is the issue of al-qada bi'ilm al-qadi. So the later scholars generally gave fatwa and most of the legal systems across the Muslim lands, the Ottomans and others, made it policy that a qadi cannot judge by his own knowledge, even if he knows decisively why. I mean, if you think about lesser authority, right? If a parent, a guardian knows that one child they're a guardian for took the money from another, they saw, Jack take Jill's money and put it in his money box, and he admits to it. So forget he admits to it. Can the guardian judge? Yes, because he knows decisively and he restores rights. And the basis is who should be a qadi? Is knowledge enough? Is knowledge enough to be a qadi?
No, he needs to be upright and wise.
Right? No, wisdom is a nice thing, but they have to have knowledge, they have to have uprightness, and the person appointing them has to be sure that this person will uphold rights and prevent wrongs, right? So not just their uprightness, but their integrity has to be well established. So there's someone like that, they saw. Okay? They're the only witness that so-and-so borrowed from so-and-so. So they know about it. Can they judge by it? The early scholars said, yes, they can. Right? But, and you can read the discussion in both Imam al-Haskafi and in particularly that no, because there's so many issues, right? Judges could be corruptible, etc. That there has to be evidence. There has to be evidence. The qadi, just by their own knowledge, of course, is not their thing. I'm pretty sure he took it, I'm going to judge against him. No, the judge saw it. It was admitted to him in private, not in front of others. Yeah? He can't, just on his ilm, his certain knowledge, he can't make a judgment. So this is something that you need to record, that the fatwa has been for a long time that the qadi cannot judge on his own knowledge. Further details related to judgeship, he says fasl. These are a series of issues. There's a structure to it. Hey, what about female judges? وَيَجُوزُ قَضَاءُ الْمَرْأَةِ. It is valid for a woman to be a judge. في غير حد وقود. In other than حد and قود, because in that Allah subhanahu wa ta'ala, out of his wisdom, has chosen that the criteria be a set number of male witnesses. So if her witness is not accepted in had punishments, then her judging in that would also not be accepted. And so this is a hukum ta'abbudi, and it's well established. But in itself, a woman is min ahli shahada, she can give witness, so therefore she can give judgment. Now, should she be a qadi? Right? Should she be a qadi? They said what being a qadi entails would normally go against what is expected of a woman. So generally, the transmitted opinion is that there would be karaha in it because of it entailing the disliked of neglecting her primary responsibilities, and also it's in a position, being a judge is a position, it's a very masculine position, right? It's a firm, aggressive, it's not, لا يتناسب, there's no tanasub with the expected temperament, and that's why, the great female sahabiyat there were muftis amongst them, like Sayyidah Aisha and others who gave judgment, Salama and others who were of the fuqaha in every generation, but qada was not generally something, but in terms of validity, it is valid. So the transmitted position would be with dislike. Okay. Another issue is, can the judge appoint a substitute? Okay, so the Qadi wants to go on a 6-month vacation. The Qadi joined Jama'at Tabligh, wants to go for 4 months on Gasht. Can a Qadi just self-appoint a substitute? No. Unless that is deputized to him. So he says, rahimahullah, وَلَا يَسْتَخْلِفْ القاض يعني ولا يستخلف قاضٍ. Right? Oh, right? 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 So he does not appoint, choose a substitute qadi. إلا أن يفوض إليه ذلك. Unless that was allowed, unless he was given authority to do that. And the substitute could be temporary or permanent. I quit, so-and-so is the qadi. تماما. بخلاف المأمور بالجمعة, as opposed to the one who has been authorized to give Jumu'ah. So the default is that the person who was authorized to do Jumu'ah, they can deputize someone. Why? Because it's hard to get permission each time. Someone got sick morning of Friday. Do you have to go and seek permission from the authorities of who will give Friday khutbah? That would cause, so the permission there would be considered implicit. And that so-and-so is the designated khatib in such and such masjid. If they can't make it, we've trusted him to give the khutbah, we'll trust him for the to do the substitution. But this would be bound by procedure. وإذا استخلف المفوض إليه فنائبه لا ينعزل بعزله ولا بموته. Right? So if they appointed the إذا استخلف المفوض إليه, right? There's someone who has been given the permission to appoint their substitute. So what happens? Here, Zubayr is the judge. He says, you know what? I quit. I'm handing this over to Shaykh Abdul Jalil. So Shaykh Abdul Jalil becomes Qadi Abdul Jalil. Right? So Qadi Zubayr handed over the Qada to another Qadi. Now the successor, فَنَائِبُهُ لَا يَنْعَزِلُ بِعَزْلِهِ. Now this successor cannot be removed by the one who appointed them. Because the one who appointed them, are they still a Qadi once they step down? No.
No.
وَلَا بِمَوْتِهِ. Right? And if that Qadi left, if they died, the person they appointed in their stead does not cease to be the Qadi. بل هو نائب الأصل. But rather they are a substitute, they are the successor on behalf of the one who has the authority, the regional or or overall authority, the hakim. وغير المفوض إن قضى نائبه بحضرته أو بغيبته فأجازه جاز. جاز here meaning صح. So someone who does not have the right to appoint a substitute. So they said, okay, my substitute is so-and-so. They didn't have a right to do that. So does that second person, so Zubayr appointed Khalid as the judge. Do they become the judge? No. So therefore, if the substitute makes a judgment in the presence of the person who illegitimately appointed him, or in their absence, but then the one who فَأَجَازَهُ, so the qadi who tried to hand over the qada validates it, it is valid. Because it's his judgment that ultimately counts, if all procedural elements were taken into account. Okay. كما في الوكالة, and the same thing with wakala. Right? That if other than the wakil transacted, but then the wakil was present, his approval is in presence is immediately an approval. Or if he heard about it, say, yeah, I'm fine with that, it would be valid. تماما. Then he says, رحمه الله تعالى, وإذا رفع القاضي حكم قاض آخر في أمر اختلف فيه في الصدر الأول أمضاه إن لم يخالف الكتاب أو السنة المشهورة أو الإجماع. And this is a sensitive issue. Right? We recognize that there's different madhabs. Right? So the basis is, the general principle is al-qada yamdi, that a legal ruling is binding. Okay, so if a ruling, so if Zubayr and Zubaydah took a matter to court, and the qadi is, and in the Muslim world, is part of the beauty of Muslim society, that in a lot of Muslim societies, you'd have Shafi'i qadis, Hanafi qadis, but if a Shafi'i qadi gives qada, can Zubayr, against whom the judgment was made, can he now take it to a Hanafi qadi to negate it?
No.
No. Because the basis is al-qada yamdi. Because it's to resolve disputes, basically, right? To establish rights, restore rights, to resolve disputes. So now, imagine if we could play legal ping pong, it'd be a fitna. Not just amongst the disputants, but also amongst the ulama, right? So the basis is that it counts. إذا رفع القاضي حكم إذا رفع إلى القاضي, if a judgment of one qadi is brought to another, what is the أمضاه, right? So the jumla is إذا رفع إلى القاضي حكم قاض آخر, all في أمر, and this matter we can sort of consider for a second. What is the إذا? What is the end of the sentence of the statement is أمضاه. He considers it binding. So he would not revisit it unless there's a need to reconsider the evidence in a way that would open the case, and he would act upon it. Right? So Zubayr, Zubaydah made a case against Zubayr that he owes her. He has to pay, make nafaqa payments, shar'i nafaqa payments, etc. So this is made against him. So it's raised to another qadi. In our madhab, that ruling may not be binding, but it's in what's called, it's mujtahad fihi, right? And the expression will take it in a matter that was differed upon in the sadr al-awwal. So the sadr al-awwal would generally encompass what? That's within the four madahib, right? That's within the four madahib. The earlier ulama would sometimes look that there are individual cases that they said, no, the Shafi'i opinion here is a later difference of opinion. We don't accept it. But when things settled down, because that was still legal dispute going on and there's a wisdom in it, it preserved, the ahkam. So in any ruling that is mukhtalaf fihi, right, that mujtahad fihi, that's subject to ijtihad, which is something that, he puts it, في أمر اختلف فيه في الصدر الأول, that the first generations, and the صدر الأول refers to the first three generations, right? And they differed. Some said only the Sahaba, that the Sahaba differed upon, but they said no, this is the Qurun al-Fadila, right? Right? This is why, there's, which is the Sahaba, Tabi'een, and Tabi'een. Right? And another interpretation, if you look in Maulana, Sheikh Zadeh, what does he say? He said that it refers to the Sahaba, the Sahaba up to the Mujtahid Imams. So in the age of Ijtihad, there was difference of opinion on this matter. Right? So it's subject to reasonable Ijtihad, then we would say it's binding. And the second judge, if a dispute arises because of the first judgment, that okay, Zubayr now, he had to pay $2,000 a month of nafaqah. Now it's raised to the Hanafi Qadi. The Qadi is not reconsidering the case. What is he doing? He would force Zubayr to act on that other judgment. إن لم يخالف الكتاب أو السنة المشهورة أو الإجماع, as long as it does not go against the Book of Allah or the Sunnah al-Mashhura or al-Ijma'. And this was something that was only in the age of where the Qadi was a mujtahid himself. Right? This is a theoretical provision. It has no, after the age of ijtihad and Qadis being mujtahid, this is not something someone else could say, I don't accept the Shafi'i opinion on this, right? And what is the parameters of that would be determined by the land. And then, some people like saying silly things about Islamic history, or just silly things in general. Say, look, the Ottomans were partisan. They only allowed, Qada by one madhab. And it was not because they were Hanafis that they did this. Why did they do this? For simple procedural matters, right? That knowledge is weak. Imagine if in a vast land, and there's large commercial transaction, trade routes from China to Europe and Africa are going through the Ottoman lands, and people are disputing say, okay, our lands have one public legal system, and this is what's binding. It minimizes dispute and makes the law clear. And that's what they did. So you can make fatwa on any position, on any school, but the qada was on one madhab. Certainly the central Ottoman lands, but they still remained other areas, Egypt, etc., where fatwa was on, there's multiple qadis there and elsewhere as well where the Ottomans had influence, right? Anyways, so that's, unless it goes against the book or a sunnah al-mashhura, a well-established sunnah. And if you want details on this, but practically it's in a matter that is subject to any reasonable ikhtilaf. Okay, that's mujtahad fihi. And we described it. وما اجتمع عليه الجمهور لا يعتبر فيه خلاف البعض. Right? So this is a matter really that belongs in the books of usul al-fiqh. Right? That scholarly consensus does not mean that there is no mujtahid whatsoever who said otherwise. If you'll find somebody who said other than what? So ijma' is the general consensus, right? Or the overwhelming consensus of the mujtahids. Right? So that's what? So it's highlighting a principle, right? لا يعتبر فيه خلاف البعض. So, that which the jumhur, the overwhelming majority of the mujtahids agreed upon, we do not consider the differences of a small number. Right? And he says here that there are, Maulana al-Haskafi has a beautiful expression. He says, وَمِثْلُهُ كَثِيرٌ وَأَكْثَرُهَا فِي التَّنْوِيرِ. And most of the examples where there are issues where there's broad consensus, but a few opinions are to the contrary. That's not considered. And very often, the people who went against the general consensus tended to be people who had methodological aberrations. Most notably, the Zahiriyya, right? The literalists. Why? Because they understood the primary texts with warped lenses. So they had, and here there's lengthy discussion in Shaykh Zada if you'd like to read it. So, for example, the Zahiriyya said that, and see, Abdul Latif, I have to send one text, but I'll send this one too. Ibn Hazm, for example, of the literal, of the Zahiri school. So the literalists did not accept formal legal analogy. And they also did not accept what we call dilalatun nas, the indication of a text. So is the permission of a virgin woman required for her to be married?
No.
Sadati? Abdul Latif.
No, her permission is not required.
So a woman that has previously married, is her, what is her permission? A woman who has previously married, she's a thayyib. Her explicit approval is required. A thayyib tusta'mar, right? Her explicit approval is required. It has to be, uttered. وَالْبِكْرُ تُسْتَأْذَنْ. And the Prophet ﷺ said, and the previously unmarried woman, the bikr, the virgin, that means the previously unmarried woman, her permission needs to be sought too. And this was new to the Arabs, because the Arab a lot of the Arabs, they would marry their daughters off, and they'd tell them, you're now married to so-and-so. So they asked, وَمَا إِذْنُهَا يَا رَسُولَ اللَّهِ? What's her permission, O Messenger of Allah? He said, إِذْنُهَا صُمَاتُهَا, or صَمْتُهَا. Her permission is her silence. So the vast majority of the mujtahids, what did they understand from that? That if her silence is permission, what does it mean? So the expression of the text, this is ibaratun nas, silence equals permission. What is indicated by the text? Dilalatun nas. What if Uncle Jamil asked Zubaydah, would you like to marry Zubair? What if she said yes? Is that her permission?
Yes.
Is that her permission?
If she says yes, that's her permission.
Well, the Prophet ﷺ, her permission is her silence. Right? So what if she says, yes, I want to marry him? Would that be considered permission from her to be married to Zubair? Right? The expression of the hadith is her permission equals silence. But what if she speaks? Is it permission or not?
It is.
See, Abdul Latif.
It
yes,
is. It's
and this
permission.
is called bil awla, right? A fortiori. Even more so, because if silence is her permission, meaning even her silence that indicates approval is permission. So if she says yes, this is even more so, right? And this is called dilalatun nas, the indication of the text, as is studied in usul al-fiqh, right? This detail there, you can find it even in the Mukhtasar al-Manar or Samt al-Wusul class for Shaykh Talal al-Azam's excellent class on the Manar. Okay. But the literalists, like Ibn Hazm, did not accept dilalatun nas. So he took it as a logical statement. permission equals silence for the virgin. So what if she spoke? Is it permission according to this literalist reading?
For the literalist, it is not, but
Abdul Latif, would it be considered permission according to them?
no.
Right? And that's shocking, right? So they said no. The only permission authorized by Rasulullah sallallahu alaihi wasallam is silence. It's almost unbelievable, right? So they held the position that if Zubaydah was asked by Uncle Jamil, do you agree to marry Zubayr? And she said yes, this is not permission, so the marriage would be invalid. And Ibn Hazm in his Muhalla, and the Muhalla is a great book, but it has these legal quirks, which is why, famously, Imam al-Ghazali's teacher, Imam al-Juwayni said, خلاف الظاهرية لا يلتفت إليه. That the difference opinion of the literalists, of the Zahiris, the Zahiri school, is not given, is not paid any attention to, because there is an error in legal, that is an error in not just legal thinking, but in understanding of language. Right? So imagine if someone says, okay, if the sheikh is silent, serve him tea, right? So you go to Sheikh Abdul Karim's place and you say, would you like some tea? He's quiet. Get him tea. So imagine that was the instruction. So if you go, the servant goes and asks Sheikh Abdul Karim, Sheikh, would you like tea? He says yes. Would anyone understand that no, my boss only accepts the permission if the guy was silent? That's not a matter of legal understanding. That's an error in understanding of what? Of language. Yes, it's an error in understanding language. They said her permission, her silence is permission, meaning that if she speaks, it's called bil awla. Right? So Ibn Hazm goes on a rant. وَزَعَمَ, his expression is وَزَعَمَ الْحَنَفِيُّونَ وَالْمَالِكِيُّونَ وَالشَّافِعِيُّونَ وَالْحَنْبَلِيُّونَ. And so he uses a rare plural, because normally what do we say? Al-Hanafiyya, wal-Malikiyya, wal-Shafi'iyya, wal-Hanabila. Right? And in Arabic, one of the ways of making someone seem insignificant is to use a rare way of talking about them. Right? You don't call them Hanafiya, you call Hanafiyun. Those Hanafis, right? And likewise, individual opinions that go against the Jumhur, the ulama may determine that this is an aberrant opinion. But that's that's an exception. So here, this is a point of ijtihad, of also that sometimes some modernists and modern literalists bring this up, right? That there's things where the ulama have stated ijma' about this, right? So be aware of this, and there's a lot more to it, but to understand it conceptually, that it is not required for the affirmation of ijma' that absolutely every mujtahid have agreed to it. Because if everyone agrees on something, and then there's like a couple of opinions to the contrary, one, we have to be sure that those opinions are not just transmitted, they're established. And sometimes it's an issue of khilaf, right? It's khilaf. But so they say, okay, that's a khilaf mu'tabar, and they wouldn't declare ijma'. But if ijma' is declared, so those opinions could be deemed, they're not always rejected. Sometimes they have sufficient basis to say, no, there's no ijma' in this. But in many others, particularly when it's based on errors in legal understanding or in errors of legal reasoning, it could be said that yes, we affirm the ijma', even though there are some individual opinions to the contrary. And this even applies to the Sahaba radiallahu ta'ala anhum. Right? Some of the Sahaba, what was their opinion about washing their eyes in ghusl? Some of the small number of Sahaba understood that in ghusl you had to wash even your eyes. In kuntum junuban fattaharu. So they would literally wash the insides of their eyes in ghusl. And in Mecca and Medina, what you would have sand in the water. So what would happen? This continual exposure to sandy water caused blindness in their old age. Now, is that khilaf of consideration? No. We would say there's ijma' that the eyes do not have to be washed in ghusl. واضح? Why? Because even though that sahabi is a mujtahid, that ijtihad would be considered to be contrary to what is correct by the judgment of the other mujtahids. Tamaman. So this is an issue we wanted to expand a little bit. We will complete this lesson, and then over here, next we have a few other issues coming up in this section, which we will complete inshallah and proceed. So the rulings on permissibility and prohibition, right? And what do they relate to, right? Because what happens is, what if there's an error in judgment? Right? What if some of the evidence was lacking? So there's some very interesting things there. So we'll continue from there. وصلى الله على سيدنا ونبينا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين. بارك الله تعالى فيكم والسلام عليكم ورحمة الله تعالى وبركاته.